Hello, I'm Sharif Ahmed before you. I'm going to discuss about a case. The case name is Riches vs. Hogben 1986. This case is between the son and mother. Mrs. Riches, actually 88 years old widow woman, and his son is 64 years old, Mr. Hogben. Mr. Hogben used to live in UK with his family, and Mrs. Riches actually convinced his son to migrate in Australia and live with her and look after her for her lifetime. If her son do so, then she will buy one house for his son's name. He promised that. And her son, Mr. Hogben, actually migrated in Australia by selling his property and leave his free rented council house and come here in Australia and live with her mother, with his family as well. And after he come to know that her mother buy the house under her name. And after his coming, just after 7 days later, her mother said him to leave the house. In this case, Mr. Hogben tried to sue Mrs. Riches as she breached the promises. In this case, I want to explain the case under the IRAC method. Here I want to clarify first that Mr. Hogben is plaintiff and Mrs. Riches is defendant here. Okay. The issue, is there any legal and enforceable contact between Mrs. Riches and Mr. Hogben? Actually, relevant law in general, Australian commercial law refers some element of the contract, and there is one element is intention. Intention is very important. Intention means both the parties should have the intention to make a enforceable contract or to bind each other legally. The intention is very important or essence to make any contract. Here in this case, if we saw, there is no written contract. It's a family issues. Actually, her mother promised him without making any legal contract. So here we can see under the common law, we can't make liable Mrs. Riches. There is another law called Family, Social and Domestic Agreement. According to law of Australia, if there is any issue relating to family or social, this is not binding in the court. However, and under the Family, Social and Domestic Agreement, the agreement is also not the bindable. But what is the exception in this case? In this case, Mr. Hogben has considerable loss in these cases by the broken promises. Actually, he sell his property in UK and he leave his free rented house as well. So it's a considerable loss. That's why we can consider this case under the property estoppel, and without written contract, this contract might be enforceable because Mr. Hogben, the plaintiff, incur a considerable loss, and this considerable loss can actually support him to gain his loss amount back or to gain his refund or something like that. So in general terms, in general terms, this contract is not bindable or enforceable, but for the considerable loss, if we consider the considerable loss in this particular event, Mr. Hogben might have some refund or have some damages from the wretches by for the breach of the promise. That's all from me.